and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. It's been a long time.
It has. We spend most of our weeks together, it seems, recording.
Qualify it like that. But yeah, okay. And here's another one.
So we're here to talk about a first-tier tribunal case that's just come to light from the 25th of June. And it's all about periodic tenancies and tenancies at will. The case is called On Tower and Others and AP Wireless 2 Limited. The case name sounds familiar. Is it a similar case to what we've done before?
Well, we did a AP Wireless and On Tower Court of Appeal case. I'm not sure when it was, not so long ago, a few weeks ago.
Yeah.
It's the same people involved, and it's all about, well, it's just mainly about a communications mass, but I'm going to steer clear of that and make it a bit more general than what the tribunal said. It's, shall I remind you of the original On Tower case?
Yes, please.
Well, that was a bizarre Court of Appeal case, which was about the fact that, well, I'd better give you some of the background to the communications stuff. There was a Digital Economy Act of 2017 that came into force for our purpose on December the 28th of that year. And cases subsequent, there's been lots and lots of cases on it. Cases subsequently said that if you've got a lease that was in existence prior to that date, it comes within the regime of the Landlord and Tenant Act 1954 if you want to go through renewal. If you've got a lease from that date onwards, then you go through a renewal under what is more beneficial for the communications operators, which would be under the code. And just to recap, I suppose, that case seems to have demolished large numbers of things we thought were leases, because leases have a fixed maximum duration they must have. And contrary to a Supreme Court case called Prudential and the London residuary body, it said that a lease for an agreement, I should say, for 10 years, which either side could terminate on 12 months' notice, terminating no earlier than the 10 years, was not a fixed maximum duration. I haven't heard the last of that. It's obviously not just applicable to communications equipment, it's presumably applicable across the board. This was the same people. There's been another subsequent case involving another 9 sites, but this On Tower was a different argument. And it's only first-tier tribunal. But shall I try and give you the background argument to it?
Yes, please.
It was there were 3 agreements in place. 2 of them involved On Tower, who'd taken an assignment of the leases, in a place called Dalkeith Farm, which is somewhere in Cambridgeshire, and Sandy Lane Golf Club in Middlesex. There was a third, which we'll leave, for the time being, Thackeray Football Club, and they all had these agreements whereby the On Tower's predecessors would occupy, for the purpose of their communications equipment. The Dalkeith Farm lease was entered into. There was a 54 Act excluded lease. It was entered into the Sandy Lane Golf Club. Was 15 years from the 3rd of January 2002. So they both came to an end, the fixed terms and also excluded, but they came to an end in 2017. The tribunal said they came to an end, not that this is massively relevant for the decision, but they said that the lease it started on the 3rd of January, came to an end on the 2nd of January 2017, and the April the 1st lease came to an end on March the 31st. That's not actually true. Fixed-term tenancy terminates on the actual anniversary date. It's the House of Lords case, Manai and Eagle Star, in 1997, following on from Sidebottom and Holland in 1895, makes that clear. But there you go. Anyway, what had then happened is after 2017, before the legislation came into force, they continued paying the rent. For instance, the Dalkeith Farm, I think, had paid its rent, yearly until January 2026. They'd already paid a year in advance. And On Tower had taken assignments of these leases in 2019 and 2020. And the question was, are they within the 54 Act? Are they periodic tenancies because you've stayed after the end of the fixed term of your excluded lease, paying your rent yearly, in which case there'd be yearly periodic tenancies within the 54 Act? Are they licenses, in which case they wouldn't be within the 54 Act? Are they tenancies at will? And why it's important to decide is because if the tenants, if they were within the 54 Act, because they've been paying the rent and so on, the tenants couldn't initiate a renewal, because Section 26 of the Act, whereby the tenants can initiate a lease renewal, only applies to terms of years certain exceeding a year, whether or not followed by a continuation tenancy, or a term of years certain and thereafter from year to year. So it doesn't apply to periodic tenancies, in which case the tenant will be in limbo post December the 28th, 2017. If it's a tenancy at will or a license, they can use the Electronic Communications Code under the Digital Economy Act, and they could go through a renewal on that process. So that's why it's significant.
So can you remind us what a tenancy at will is?
Yeah, it's a strange concept whereby you've got a lease, you've got exclusive possession, but at any time, either side can bring it to an end. And people tend to think that tenancies at will, once you start paying and the landlord accepts rent, become periodic tenancies. So this would be within the 54 Act when the old leases came to an end. And that's not so. I mean, that's quite clear. So I'll give you some of the history of it. The history goes back many years, but there was a case, Jarvin and Akeel, back in 1991, a Court of Appeal case, that said there's not this automatic presumption, everything depends on its facts. And in that case, for instance, it was understood that they were negotiating the final lease, and they paid, the tenants paid 3 months in advance. Negotiations drag on. They paid another 3 months in advance. Negotiations drag on still, another 3 months and another 3 months. And the tenants argue, I've got a periodic tenancy, I'm in the 54 Landlord and Tenant Act, you can't just tell me to go. And the Court of Appeal decided that it's understood between the two of you, you're negotiating the final lease, and that's a tenancy at will. Everything depends on its facts, but there's a tenancy at will. There's another case called Aramis, and Aramis Housing Association, Barclays Wealth Trustees, from 2014, a Court of Appeal case where the initial fixed term excluded lease came to an end, and the two of them, they start continue negotiating beyond the end of the fixed term. The tenant was paying their rent yearly in advance. And again, the court, in this case, the Court of Appeal, said it's the tenancy at will. The tenant cannot just up and leave without notice. If it had been a periodic tenancy, they'd had to give yearly periodic 6 months notice terminating on an anniversary date. And they made it quite clear that there's no automatic presumption of a periodic tenancy just because you're paying your rent. Everything, again, depends on its facts. There was a couple of cases. There was a case that went against it called the Smoke Club and Network Rail Infrastructure, which was near London Bridge Station. It was a bit different because it wasn't about 54 Act renewals. Near the Shard, Lizzie. But it was a bit different because it was about compulsorily purchasing with Thameslink. And they said in that particular case, if you've got exclusive possession and you're paying a rent, there's a strong presumption, but it can be rebutted. But in this particular case, it wasn't rebutted, strong presumption of a tenancy at will. And there was a couple of cases, I think we did podcasts on, one in particular called Valley View and the NHS Property Services in 2022. Which was a medical practice with the tenants, and the idiot landlords were the NHS Property Services. And they'd moved in 2007, hardly negotiated at all, half-heartedly negotiated over 14 years. I don't think they can negotiate at all for the first 4 years. And I found amazing at the time that the court decided that was also a tenancy at will. And this particular case said, because there's, the tenant will not be able to initiate their lease renewal process, and if the landlord doesn't bother serving a Section 25 lease, the lease is not going to be renewed. For that reason, and for the fact that there's separate statutory protection, and there have been a series of cases over since 2018, which the parties would have known about, that because they were involved in quite a few of the cases, or their predecessors were, then it is a tenancy at will. There's no evidence they intended a periodic tenancy, and you need that evidence. So that's what that one, and I think we've not heard the last of it. Yet another nail in the coffin of the 54 Landlord and Tenant Act. I say the background facts do depend on the fact, whether the Communications Code applies or the 54 Act. But I'm sure you can sort of extrapolate, that's a good word, to leases more generally. Courts have decided to indirectly get rid of the 54 Act. Tenancies at will, I should have said, don't come within the 54 Act. It's a case called Wheeler and Mercer in 1956 said that.
Thank you very much, Richard.
My pleasure, Lizzie. And until the next time.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.